Okay, the next case we have is Bonnie Carrasco versus Samuel Strader. And y'all had a request to take this off the YouTube? Is that correct?
I, I did, Your Honor. But
Okay.
if it's gonna obstruct procedure, then we can proceed.
No, I just need to know the reason.
The reason is invasion of privacy.
Okay, because Texas courts are considered public.
Okay, well, if anybody wants to obtain public record to these proceedings, they can do so, but they don't need YouTube to do it.
See, because we're doing it over the video
Oh,
and not
okay.
in a courtroom, we have to have some way to make it public. And so that's what they came up with, was to just put it on YouTube. It's not being recorded.
Yeah, I mean, I guess I understand that, but not really, but that's fine. We can proceed.
Okay. Let's see, Ms. Carrasco, let me, and Mr. Strader, let me swear y'all in. Do each of you swear to tell the whole truth and nothing but the truth?
I do, Your Honor.
Okay. And Mr. Strader as well?
Absolutely.
Okay. Now, Ms. Carrasco, I've been through the evidence that y'all submitted and the petition, and I know this concerns a loan that was made on November 6th of 2023. And the contention you're making is that it was a loan.
Yes.
And you've been trying to collect on that loan.
Yes.
When was the first time that you, if you can recall, as I said, that loan was in November of 23. When was the first time that you made an effort to try to collect on that or talk to your son about collection on that?
In February.
In February of 24? Okay.
Yes.
And
also, Your Honor, I'd like to point out that any reference to my medical condition should be stricken from the record. He had no business admitting it. He is not a trained psychologist.
right, that's not relevant. It's not
Correct.
relevant. So that was in February.
Yes.
And what other efforts did you make besides the
Well, I can tell you this. 2 days after we filed the court almost a year ago, he came into my house intoxicated with George Ferguson and said, "Meet me at the bank." 2 days after he was served.
After he was served? Okay, because this was filed on March 21st of 24.
Yeah,
So
he came in, and once the constable served him, he arrived at my house, said, "Meet me at the bank," said an F word to George Ferguson, and said, "Meet me at the bank tomorrow. You sent the police to my house." The day after he was served.
The day, okay, and what happened then?
I said, "I don't need to go to the bank. You're intoxicated." You said, "F you to George." There's evidence said we can have a civilized conversation.
Before we dive into this case, let me set the stage, because what you're about to witness is not your everyday loan dispute. This is a mother dragging her own son into court over a $10,000 loan, a trail of text messages that flip between apologies and accusations, and a dispute so personal that one party even tried getting the hearing removed from YouTube. And trust me, that request alone tells you the emotional storm swirling beneath the surface. This case is everything. A judge trying desperately to keep the focus on the law, a mother shaking with frustration, and a son firing off texts that range from defensive to downright hostile.
His finances are his own business. He didn't accept the settlement. That I know that happened.
Correct.
But,
now, if you look at Sunday, February 18th, I need $250 by the 1st. I'm fat effing broke. I apologize for my language in advance. You agreed to make a payment plan, and I haven't seen your payment. So what is your plan? You also see, have Aaron or Paula call me at the bank, because he banks where I bank, Your Honor. By the way, this is Sammy. This is business. He says this is extortion. This is him talking to his own mother.
Is that filed in the exhibits that you sent?
Yes.
which one is that in?
By the way, this is, extortion. It's February 18th to Saturday, March 23rd at 4:16 p.m.
Well, it's first you send in that plaintiff's exhibit packet, and then you sent in plaintiff's account history and loan and security agreement. And
Right.
that bunch of evidence. Do you know where it is?
What do you mean?
What you're quoting from, the extortion statement. In which of those exhibits is it in?
It is, dated Saturday, March 23rd at 4:16.
I just don't.
It's a text message.
Right. I'm just not, I don't remember reading that part.
I can show it to you. It's right here, Your Honor.
Pardon me?
Can you see it?
Oh, okay. Okay. See, I just don't remember. Okay. Go
Okay,
ahead.
so hold on.
Mm-hmm.
Can you see where it says this is extortion?
Mm-hmm. Yeah. Okay. And that was February 18th?
March 23rd.
Oh, that was March 23rd. Okay. Go
Yep.
ahead.
This exhibit, Your Honor. Can you see it, Your Honor?
Mm-hmm. Yeah. Go ahead.
Can you see what he's saying?
Yes. Now that one I saw.
Can you read that for the court, please? And on the record?
Oh, it's in there. It's in the,
I'm going to nominate you for Mother of the Year. No arrest in 13 years. Wow, it's really amazing.
Here's what's interesting right out of the gate. Before we even get into the loan dispute, the first point of tension is the son's request to remove the case from YouTube. That alone gives us our first clue. Someone doesn't want public accountability. If you're confident in your position, you don't scramble to hide the hearing. But when you know the receipts, texts, and behavior won't paint you in the best light, suddenly privacy becomes a shield. The judge handles it perfectly, reminding both sides that Texas courts are public. And notice how quickly the son backs off when he hears that removing the YouTube stream won't alter the fact that the case is still a matter of public record.
That's coercion. No arrest in 13 years. He did a background check on his own mother when he's a convicted felon.
well, we're just talking about the nature of the loan right now.
Correct. You see this, Your Honor? He banks where I bank. I called my bank. They said, you don't need to go into the bank with Sammy because frankly, he scares me.
Mm-hmm.
I don't even want to see his face during this. I'm a nervous wreck.
Mm-hmm. Okay.
I said, call him or Aaron, call me because he banks where I bank. And
Uh-huh.
you don't even need to be here. We'll put the money in the bank. He did not.
Okay.
And P.S.
Okay.
Ask him why he borrowed 10 grand. Ask him how much he spent on his wedding. Because I know.
Well, we're
And
just,
I believe, Your Honor, with all due respect, this should now become a community debt should I win the case.
Now we're stepping into the core of the dispute, the loan itself. Notice how calm, direct, and organized the mother is when laying out the timeline. Loan in November, attempts to collect starting in February, repeated follow-up messages, and even offering a structured payment plan. This isn't someone acting on impulse. This is someone who patiently tried to resolve things without legal action. Meanwhile, she points out something crucial. The son brought up her medical condition. That's a classic deflection tactic. When someone can't disprove the financial evidence, they pivot to personal distractions. The judge shuts that down immediately, making it clear none of that is relevant.
You see how bad I'm shaking.
mm-hmm.
Why would I say, oh no, Sammy, I don't want your 10 grand. That's an outright lie.
Mm-hmm. Okay.
and you have no case. This is his arrogance.
Mhm.
And we're just about done here. You see this exhibit? I'm willing to have a civilized conversation about this without your
Mhm.
bodyguard. That was George. When he
Mhm.
walked in and said, fuck you to George.
Mhm.
You see this? You are a psycho narcissistic. Read that, Your Honor, with all due respect. You're going to talk this way to your mother who let you live here and walk out of my house with $15,000.
Okay, we're just gonna talk about the
I
loan.
understand.
We're not gonna talk about the tenor of his other statements, just the loan.
Again, Your Honor, at the bottom, I am willing to pay half.
Mm-hmm. Mm-hmm.
Again, Your Honor, show his arrogance. Your first mistake is thinking you can tell me what to do. You see it?
See, that's what I don't want to hear stuff like that right now. I just want to hear about the nature of the loan.
Okay. Well, I think I've submitted enough evidence. Do you have any questions for me, Your Honor?
No, not at this time.
Thank you.
But you are requesting return of the $10,000. That's what you're asking
I'm
for.
willing to settle the case right now today for $5,000.
If he wants to do that for $5,000.
Yep, that's giving him half. Oh, one more thing.
Mm-hmm.
That he's taunting me. Free legal advice is nice. Who does that to their own mother?
This is where the situation shifts from a simple repayment issue to something much more chaotic. The mother explains that just 2 days after being served, her son showed up at her house intoxicated, demanding she meet him at the bank. That's not a repayment plan. That's pressure mixed with panic. The judge listens carefully, and you can almost see the picture forming. A son who wants to appear cooperative, but only on his terms, and only when emotions are running high. Her response is exactly what a reasonable person would do. Decline to engage with someone intoxicated, suggest he deposit the money himself, or set up a payment plan. And the fact that he banks at the same institution means there were zero obstacles.
Well,
This was never a loan. I mean, if you want some background, I can give it to you.
well, first I want to know if you accept the offer.
No.
5,000. Okay. Okay, go ahead.
Do you have any questions, direct questions for me, or do you just want me to do what she just did and tell you the whole story?
I just want to know the kind of the presumption in law is that it is a loan. You
By
need to
whose
establish it was a
standards?
gift. That's the legal,
I mean, how has this been proven a loan thus far?
because she is indicated that it's a loan. She says it was a
Okay.
loan.
Okay, but it's my word against hers, right?
Well, that's what I'm saying. The legal presumption is that it is not a gift. And you need to tell me how it is a gift.
Okay, because she told me to keep it on the phone, which is on record with Consumer Cellular, which unfortunately you can't subpoena phone calls because this is not Law and Order. This is not TV.
Right.
However, that's how it went down. $10,000 to a guy like me is life-changing money. And she also left out the part where she had a house picked out on Oak Alley right around the corner from her house for $450,000. And I quickly assessed the situation and said, there's no way possible that you can buy a house in Austin, Texas for $450,000 with $10,000 down. So I said, we're not buying a house. I'm 53 years old. I'm not hitching myself to a mortgage. And it's impossible to do with only $10,000. So I can either pay off some bills with this or I can give it back. She said, keep it. It's a gift. She was happy. She was living her life. She was doing her thing. She was spending money all over the place. And I was happy for her. I was like, well, maybe it'll stick. And it didn't. So, I mean, if you read the evidence that I submitted, the letter that I wrote to the court, it's almost verbatim. You don't have to remember anything when you're not lying. This is actually what happened. And then right after that, she said, don't tell Ben. Ben is my brother. He's a very successful family court lawyer.
Mm-hmm.
And she said, don't tell him. And I said, well, that's no problem. We never talk.
Mm-hmm.
What does she do 2 weeks later? She tells Ben. Ben goes ballistic because he's entitled, he's selfish, and he's...
Now we hit the text messages, the heart of the evidence. These messages are incredibly revealing because they show the emotional temperature of this mother-son relationship. The son accuses his mother of extortion, which is wild considering extortion requires threats. Asking someone to repay a loan they agreed isn't extortion. It's basic accountability. And the judge's reaction is telling. He doesn't even remember seeing that message, likely because it doesn't align with any legal definition. The mother, meanwhile, presents these texts as receipts of his shifting tone. One moment he's hostile, the next moment apologizing or negotiating. It's a pattern. These inconsistencies hurt him because they unintentionally admit the debt exists.
To have is because I thought she had borrowed that money to give to me. But no, she didn't. It was cash money. Now, if she'd come to me in the beginning and said, look, I made a mistake. I don't have $80,000 at the end of the year like I told you. I need that money back. Can you help me out? Yeah, no problem. I got your back. But she started threatening and wanting to sue. And all this came right on the coattails of telling my brother, which she told me not to do. She wants to please him. This whole thing is about him. As soon as she told him and he got upset, then it became a loan. All of a sudden, it's a loan. Oh, I want the money. I told Ben you were going to pay me back. I said, why did you tell him that? I'm not paying you. That money's gone. I used it to pay off some things and to put a little cushion in the bank for myself and to be comfortable. Like I said, $10,000, Your Honor, is life-changing money to blue-collar workers, to guys like me. This thing is all about her winning. She wants to win. That's all it's about. It's not about the money. She's not broke. She doesn't need it. She's retired. She's bored. She's depressed. I'm not going to get into any more of that, but I'm shaking too. You just can't see it.
Mm-hmm. Okay. Anything else?
No, ma'am.
All right. Miss Carrasco, you're the plaintiff, so you get the last word.
Ben's testimony is hearsay, Your Honor. There's no proof of that.
Well, it's not hearsay, ma'am, because he's a party.
Excuse me?
It's not hearsay because he's a party. You guys are using legal words you don't know the meaning of.
Oh, okay.
Yeah, no, thanks.
Well, you saw the evidence. He agreed to pay it back or give it back, and he borrowed 10 grand, and he makes $62,000 a year at the city of Austin.
I never borrowed anything from you. Admit the truth.
Mr. Strader, this is her turn to talk.
You lived with me, Sammy, for a year and walked out of here with 15 grand. I never charged you.
Ms. Carrasco, you address your words to the court.
Okay. He lived here, Your Honor, and walked out with 15,000. I never charged him. I helped him get a job. I helped him open a bank account.
This section is where the emotional tension truly explodes. The mother reads out insult after insult, name-calling, accusations, and disrespect. But watch the judge closely. He repeatedly redirects the conversation back to the loan. That's what judges do when someone tries to win emotionally rather than factually. Her shaking and raised voice show how deep this wound runs. This isn't just about $10,000. It's about betrayal, disrespect, and a breakdown of trust. Yet, the judge refuses to let the emotional chaos overshadow the legal issue. Was this money a gift or a loan? And every time the son says, I'll pay half, He undermines his own defense.
Okay, we have certainly understand that's okay. People get emotional. All right. Well, based on the evidence presented, I find that the plaintiff has established a cause of action for $10,000. I will enter a judgment on her behalf for $10,000 plus court cost. Each party does have at least 15 days to file a motion for new trial and 22 days to appeal. Any
Your Honor,
questions about?
Your Honor, can I ask you a simple question?
No.
Where is the evidence that this was ever? Where is my signature on anything? Where is there a payment
Mr.
plan?
Strader,
Where? How has this been proven?
if you want to appeal, please feel
I will be
free.
appealing. I promise you that.
Excellent.
Your Honor,
We
I have
will
one
have
question.
a copy of the judgment out at the conclusion of this hearing, and the appeal bond is set at $20,000.
What is an appeal bond?
And if you need an indigency affidavit because you cannot afford the appeal bond, that will be provided as well.
What
You can
is an
use it.
appeal bond?
That's what you put up for the appeal so that you
I
can.
mean, I don't understand. What do you mean?
Here's where things take a surprising turn. The mother suddenly offers to settle the entire case for $5,000, cutting the original amount in half. That's a massive concession, and it shows she isn't driven by greed. She just wants resolution. In courtroom terms, this makes it look incredibly reasonable. Meanwhile, the son's mocking messages and refusal to engage constructively only highlight how avoidable this entire case was. Instead of paying back even a portion when he had the chance, he dragged his feet, insulted her, and ignored multiple attempts to settle privately. Judges notice these patterns. Settlement offers can heavily influence how they interpret credibility, fairness, and intent.
Good lawyer, okay?
No, it's not, but it ought to have some facts.
It may have something, but you could be very easily misled by what you read. Okay?
So what if I refuse to pay? I will never pay her a dime. I will never pay her a dime. This is a fiasco. I do not owe her this money. I never asked to borrow this money, and I will never, ever give her a dime.
Thank you for appearing today, and I hope you have a pleasant.
Officer Langwise of the Naples Police Department. The reason I'm stopping you is failure to come to a complete stop at the stop sign.
Oh, I thought I did. I'm sorry.
It's okay. Is this your license and registration?
I no longer use a license. I only have my passport that I use. I'm a state national, so I no longer have to abide by the corporation's rules, and I have my documentation for that.
Okay.
Those were previous citations that were dismissed by Judge Crone.
Yeah, this doesn't show me anything of why you don't have to have a driver's license, so.
I'm a state national, so I'm exempt from the problem or the what you guys do. I'm exempt from the.
Usually you have a card on you that states that they give you that you're exemplary.
Yeah, they haven't sent it to me yet, but I have filed all the paperwork and it's been in place for 6 years.
It's been in place for what?
6 years.
And you don't have, if it's been in place for 6 years, you don't have the prior one?
They didn't send it to me yet.
In the whole entire 6 years, you've never had anything?
You know how our federal government works, so.
So what do you provide for documentation wherever you go? You only provide...
Ma'am.
You should have been at least issued...
And that brings us to the end of this tense and emotional courtroom showdown. When you strip away the insults, the panic, the intoxicated visit, and the endless text messages, the legal issue remains simple. A $10,000 loan that was never paid back. The mother presented consistent evidence, a clear timeline, and numerous attempts to resolve things peacefully. The son presented deflection, emotional volatility, and accidental admissions that he owed something. It's a powerful reminder. Family loans can turn from help into heartbreak. And once they reach a courtroom, the judge doesn't care about the family drama, only the fact.